Good afternoon. I'm Heather Hughes with Public Entity Partners, and I'd like to welcome you to today's Partnering for Success webinar, Local Government Employment Claims You Can Avoid. This webinar will be presented by Attorney Casey Crane. If you have any questions during the webinar, please put them in the chat box and we will address them as they come in. Casey is willing to address all your questions, so feel free to chime in as they come into your head so you don't forget what your questions are and we can get them answered. Casey Crane joined Fair and Bates in 2017. Her practice focuses on general civil litigation, including municipal liability defense, civil rights defense, police liability defense, governmental tort liability defense, employment law and discrimination, and trial and appellate litigation. Prior to joining Fair and Bates, Casey previously served as an associate for Myers Nave, specializing in First Amendment and public law matters for public agency clients. Casey obtained her Doctor of Jurisprudence in 2006 from the John Marshall Law School in Chicago, Illinois, and received a Bachelor of Arts degree in 2002 from the University of North Alabama. We will be recording today's webinar, and all registrants will receive a copy of the link to the recording should you want to share this with anyone in your entity. But now, with no further ado, to present Local Government Employment Claims You Can Avoid, Ms. Casey Crane.
Thank you, Heather, and thank you everybody for being here today. So today I'm going to give just a broad overview of the federal and state claims I see most frequently with my clients. So we're going to talk about federal and state statutes and a couple of constitutional matters. And as Heather said, please just chime in if you have any questions. Since we're covering so many topics, I might not know all of the answers, but I can get back to you if that's the case. And there's one statute I want to make clear I'm not talking about today, and that's the Family Medical Leave Act. That is just such a complicated and comprehensive statute. I think we should probably discuss that one by itself on another day. But to get started, the first statute we're going to talk about is the Americans with Disabilities Act, which I'm sure you're familiar with. The ADA is a federal statute, and it prohibits the discrimination against individuals with disabilities. The ADA it's incredibly comprehensive, and it covers 5 main protected areas. That's employment, transportation, public accommodations, communications, and access to local government programs and services. So as cities and municipalities, you guys might run into the ADA a lot in these different types of areas, but we're just going to focus on employment today. Next thing I want to point out is who is an individual with a disability. So under the ADA, an individual with a disability is an individual who actually has or is thought to have a physical or mental impairment that substantially limits a major life activity. The part of this definition I think that is up for the most interpretation, or that's the most vague, is a major life activity. So the courts define what a major life activity is, and that changes based upon what court you're in. We're in the Sixth Circuit, but generally a major life activity includes caring for oneself, performing manual tasks, seeing, hearing, sleeping, standing, lifting, bending, speaking, anything that you think of just a normal life activity, right? It also includes some major bodily functions. So for example, people that have immune disorders, digestive and bowel issues, bladder issues, neurological issues. The point is there is no exhaustive list. And in recent years, it seems to be that the list of what a major life activity is expanding, or what a physical or mental impairment is. So just wanted to give one example. There is case law, including case law in the Sixth Circuit, that suggests that alcoholics or people that are addicted to drugs could be considered disabled under the ADA. That does not mean that an alcoholic has to be given a reasonable accommodation so they can drink on the job, right? It's not that broad, but it may require that someone with the alcohol dependency issue or someone with the drug addiction problem have a reasonable accommodation, such as having time off to attend a rehab facility, right? So that would be a reasonable accommodation under the ADA for somebody who's disabled. And throughout today, I'm going to just give you some examples of what I've seen with my clients, some cases that I've had in recent years. So this is one issue that has not been resolved yet, and it's still pending, but I represent a local government client who operates a jail. And there was a corrections officer who this is a county client. The county found out that that employee was taking a prescription narcotic drug that's used in treatment of opioid addiction. Sorry, I can't talk today. So when the jail found out that this person was using a narcotic, they terminated the employee. It was in violation of county policy, which to me makes sense. You know, you don't want someone using a narcotic while they are holding a weapon, transporting inmates back and forth to jail and to court. This individual filed a claim with the EEOC regarding his termination and filed a claim under the ADA. And his allegation that his recovery and drug addiction made him or qualified him as a disabled person under the ADA. And I'm going to kind of go through what the process is when people file charges of discrimination, but this was referred to the Department of Justice, who has been investigating this for several months. And no court has ruled on this yet as to whether or not it was a violation of this individual's rights under the ADA to be terminated based upon taking this drug, which is a treatment for an addiction issue. But I can tell by the questions that the DOJ has been asking that they're focusing on whether or not the termination was based upon the fact that the drug let the county know that this person is a recovering drug addict, or if it really was based upon an inability to perform the essential functions of his job based upon taking this treatment, this drug as a treatment. So I just use that example to kind of show that who is considered disabled under the ADA can range from somebody who has, a chronic back issue and they can't lift things, from someone that might have, for another example, someone who had IBS and didn't have to take leave under the FMLA, right? This is just an issue that came up every now and again, but had requested an accommodation that they work remotely. So now that we've kind of discussed who might be considered disabled under the ADA, let's talk about how it might apply to you. So the ADA applies to private employers with 15 or more employees, or to state and local governments. So if you're a city, the ADA is going to apply to you. Again, as we discussed, it protects qualified individuals with perceived disabilities or an actual disability. So qualified individuals means someone who is able to perform the essential functions of a job with or without reasonable accommodation. And usually essential functions of the job will be determined by like a job description. So I know cities typically have pretty thorough job descriptions, but it's pretty imperative that you have detailed job descriptions. So if an issue comes up with someone who says that they're unable to perform the functions of their job, that you can explain whether or not this is an essential function. And it's not dispositive, but if it's listed as an essential function in a job description, that's a pretty good indicator. So they're qualified if they're able to perform an essential function of a job with or without reasonable accommodations, right? And another key thing about this definition is it protects qualified individuals who are actually disabled or who are perceived disabled. So It's enough. The case law suggests that it's enough if an employer just believes that an employee is disabled. And unlike some other statutes like the FMLA, you don't necessarily, someone doesn't necessarily have to provide a doctor's note to you in order for them to qualify as a disabled person under the statute. So the statute requires that employers provide reasonable accommodations unless it would result in an undue hardship. And we'll discuss that a little bit more in a second. So if an employee, a former employee, decides that their ADA rights have been violated, they are going to file what's called a charge of discrimination with the EEOC. So that must be filed within 300 days of whatever adverse employment decision they're challenging. So that could be that someone is passed over for a position, someone's not hired for a position, they're terminated. So the process is an individual would file a charge of discrimination with the EEOC. This can be a very informal process, and usually it's just a form that they fill out. They don't necessarily have to have counsel. The EEOC is supposed to be a neutral body, but I think in practice, they're more sympathetic towards the employees. So sometimes they'll have assistance with, a representative from the EEOC. They're helping them file this charge. After the charge is filed, you as the employer will receive notice from the EEOC. The next step will be the EEOC sending you a request for information, right? That could be about just answering questions similar to interrogatories, or requests for production of documents, use of the position statement. What's unique to local governments, it's typically the process is the EEOC will investigate this charge of discrimination. And in the past, I would say 90% of the time, the claimant would receive what's called a right to sue letter, right? It doesn't mean that there's been no discrimination or the EEOC hasn't made a determination either way, but it just allows somebody to then file a lawsuit, right? They have to have this right to sue letter before they can file a suit in courts. With local governments, if the EEOC finds that there is cause after their investigation, which is happening much more frequently now, the EEOC will refer the charge or the claim to the Department of Justice. So if it's a private employer, if the EEOC finds cause, the EEOC could potentially be a plaintiff against an employer. Local governments are in this unique position where the EEOC can't be the plaintiff against a local government. So this is happening much more frequently now, where these matters are referred to the DOJ, and then you have to deal with responding to the DOJ while they perform their investigation. And again, yeah, I think this happened much less frequently in years past. In just the last few years, I've had 3 clients have charges of discrimination referred to the DOJ. It's not a fun process. I hope none of you find yourselves in that situation. But let's talk about some of the best practices in order to kind of avoid that, or avoid having some kind of cause determination found by the EEOC. Employers must engage in what's called an interactive process with an employee who is disabled or perceived to be disabled, who reports that they no longer can perform an essential function of their job. So the interactive process is really just a discussion. It's a discussion between HR or whomever is responsible from the city with the employee to determine what the scope of the limitations or disability is, and to discuss what reasonable accommodations might be made in order for a person to be able to perform the essential functions of their job. And the trigger is not, it's not like a formal request. Someone does not have to say, I think I'm disabled under the ADA and I need a reasonable accommodation. The courts are going to hold you as the employer to a higher standard that you should know generally about this statute. So if as soon as you're aware that somebody might have some type of mental or physical impairment that's limiting their ability to perform the functions, essential functions of their job, it's really the onus is on the city, HR person, whomever, to open up that dialogue. And I said earlier, to be considered or qualified as disabled under the ADA, you don't necessarily have to have documentation from the doctor, right? But once you start this interactive process, it's completely appropriate for you as the employer to determine what the scope of this individual's limitations might be. So you might have to ask that employee for a medical release and get additional information from their treater to determine what the extent of what they can do with their in that position. So once you kind of determine what the extent of the disability is, that's when you continue this interactive process to discuss reasonable accommodations. So a reasonable accommodation is something that does not require an undue hardship for the employer. So it's some kind of shift or change that you can make in that employee's job functions so they can continue in that position. So some examples of reasonable accommodations are making facilities readily accessible and usable for someone who might have some kind of physical limitation, relocating or redistributing duties that an employee might have to somebody who is able to perform those duties. It may be like a shift, like an exchange of duties. So, the employee who's absorbing the new duties is not overwhelmed. Another one is adjusting a work schedule or permitting employees to have time off to go to, chiropractic appointments, to see treaters. An example, I alluded to this earlier, is I had a client who had an employee that had IBS, and there was a litigation that was filed and we settled it, but based upon kind of feedback that we got from a mediator, a reasonable accommodation in that case would have been allowing remote work at some time, right? To mean that this employee would be allowed to work remotely all the time, right? If his or her job might not allow for that, but allowing some exception for remote working when possible. So it's really important that you go through this interactive process, and that way you can kind of show your work, right? Let's say if this gets to the level of the EEOC or to a federal court. And that's why it's crucially important that you document. I've seen clients that have had ADA charges and they unfortunately have to learn the hard way. As we know, sometimes it's a very informal work environment, but it's crucial that when you're having these discussions and you're engaging in that interactive process, that you keep contemporaneous notes about what you all discussed, that you are perhaps emailing the employee to confirm what you discussed during that interactive process. You just want to have documentation so you can show that that you as a city attempted to provide a reasonable accommodation to a qualified person. And unfortunately, if you do go through this process with the EEOC and it ends up in federal court, the damages, the exposure to the city can be significant. So a prevailing plaintiff could be entitled to recover compensatory damages, which means out-of-pocket damages, pain and suffering. Those are subject to statutory caps, in addition to back and front pay. And I find in most cases, the biggest threat of exposure in these cases is that the prevailing party or the prevailing plaintiff is entitled to attorney's fees and costs. That number could be astronomical, right? So especially in federal court, litigation can last a year and a half. And if you get away at trial, I mean, I think the fees and costs can be significant, but also even if you're trying to just get to a settlement, plaintiffs' attorneys will claim to have expended significant amount of time in representing their client. So that's the American with Disabilities Act, or the ADA. The next statute I want to talk about is Title VII of the Civil Rights Act. Title VII is a federal statute, and it prohibits discrimination against people in specified protected classes. So those protected classes include race, national origin, gender, and gender identity. And I want to point out, there's a somewhat recent Sixth Circuit case, which that's the jurisdiction, the federal jurisdiction where Tennessee lies, that Title VII applies to and protects transgender people. Religion is a protected class, and sexual orientation is a protected class. So as with the ADA, Title VII applies to private employers with 15 or more employees or local governments. So it's going to apply to you if you're listening to this presentation today. And it prohibits harassment or retaliation against folks in that protected class. I also want to point something out that came up in another recent case of mine. It also protects retaliation or harassment of employees because they either opposed a discriminatory or harassing practice, or they participated in an investigation into the discrimination, harassment, retaliation of a person in a protected class. And this came up in a case that, again, was referred to the DOJ, and it involved, I think it was like 15 women who made allegations about sexual harassment and sexual assault, quite frankly, against a department head. There was an additional claimant in that case, and it was a male that didn't qualify as a protected person under Title VII, but the basis of his claim was that he spoke out about this harassment to the supervisor, and he alleged that the supervisor retaliated against him by changing his shift or making other, kind of adverse employment decisions against this male employee. He also alleged that when the EEOC began investigating these charges of discrimination by the women who are members of the protected class, that the county retaliated against him as a result. I point that out. So if you are performing an internal investigation or review of a claim about harassment or discrimination, it's very important that when you talk to witnesses, you tell them that they will not be subject to any retaliation as a result of their participation in the investigation, right? And it's just, the flag to have, or something to keep in the back of your head if there are unrelated performance issues with that individual, that there could be a potential claim that he's being retaliated against. So if someone has been involved in an investigation about Title VII, if they do have other, disciplinary issues, I'm not suggesting that you cannot discipline an individual, but be extra careful in documenting what's gone on or why that person is being disciplined or, subject to some kind of adverse employment action. But in Title VII, their most frequent claims that you're going to see are individuals who say that they were terminated, they weren't given a raise, they were somehow treated differently based upon their membership in a protected class. And to kind of prove up that claim, they're going to have to show A, they were a member of a protected class, B, that the city or the employer knew that they were a member of a protected class, and that the adverse employment action was based upon their membership in that protected class. A defense of the employer is a legitimate business reason or a legitimate reason why that adverse employment action was taken. So again, this kind of underscores just something I'm going to stress throughout this hour, is that it's so crucial, that you're documenting everything, even things that might not seem significant. So, again, someone makes this Title VII claim, you say, no, I have this legitimate reason. This person is late all the time, right? That's your reason. Then it goes back to the claimant or the plaintiff to say, no, that's mere, what they're called pretext. They're going to say, no, you're just using that as an excuse. It's really the discrimination or harassment. So the defense to that is going to be, no, this is not pretext, but you have to, again, show your work to the court, or hopefully when it's even earlier, to the EEOC. And in doing that, you need to show your work that I have all this documentation about these, performance issues by this employee. And it's important that you're documenting that for everybody. So a plaintiff might say, no, that's mere pretext. Joe and Sally, who are not members of this protected class, had the same performance issues, but were never disciplined, right? So it's very important that that supervisors are trained in this, that HR folks are trained in this, that everything should be documented in order for the city to rebut allegations about harassment or discrimination. And just to note how these harassment and retaliation claims are shown, or more of the retaliation or discrimination, is either through disparate impact or disparate treatment. So disparate impact is often referred to as unintentional discrimination. So that's when an employer's policies, practices, or procedures are unbiased, but end in a disproportionate impact on a protected group. So an example in case law that you'll see often, or pre-employment tests that are given, right? The pre-employment tests are given to everyone, but only one group is eliminated based upon that test. So there's some kind of inherent and unintentional bias within that testing. Disparate treatment is intentional discrimination, where a member of a protected group is singled out and is forced to take part in a test, like a pre-employment test that no one else is forced to do. Again, I think Title VII has been around long enough. You see less of these kind of disparate impact and disparate treatment claims. I just wanted to point that out nonetheless. So under Title VII, I've seen an influx of sexual harassment claims, and this, I think, was triggered somewhat by the Me Too movement. And again, I referenced this case I had a little bit earlier, where it was a massive case against a county where you had, over a dozen women claiming sexual harassment. And there is a defense, right? There's a defense that you hope you have in your pocket if one of these claims comes up. And it's called an affirmative defense. And it has to do with whether or not the city had an adequate sexual harassment policy in place. The employees, including the employees who were asserting the claim, were aware of the policy, but never reported the harassment to the city. So for example, if someone makes an allegation that their department head sexually harassed them, if the city can establish that they have these policies, there was an acknowledgement of the policy, but no one ever reported the harassment to the city, that is a potential affirmative defense to sexual harassment claims under Title VII. But it has to be an adequate policy. And I know a lot of folks get their policies, their form policies maybe from MTAS. But it's I think in the last couple of years, it's become clear it's a good time to review your policy and make sure that it adequately addresses sexual harassment, how folks can report, that folks are actually trained in sexual harassment. I think once a year is necessary at this point. Adequate policy would include that you're getting signed acknowledgements from every single employee when they're onboarded, right? So, and what I suggest to my clients now, especially after this case that I had, is that you provide training once a year. So, but back up. Every employee is provided with a copy of the sexual harassment policy and signs acknowledgement of the receipt of the policy. That you're training in sexual harassment at least once a year, recording that training. So when you have new people that are hired, you can show them a recording of the training. Another important part that kind of came up in this DOJ investigation is the ability to report harassment to someone other than the supervisor, right? And sometimes when you have small cities, the supervisor might be just the city manager. So you want to have provisions in your policy where there's just kind of this step up where they can report it to their immediate supervisor or report it to the city manager. And if city manager is the immediate supervisor, that it can be reported to city council or BOMA, someone else. Another best practice that the DOJ is suggesting is having some kind of anonymous reporting system. That does make it a little bit more difficulty to investigate these harassment claims, but it allows folks to report harassment without, the fear of some kind of reprisal or retaliation. And again, I'm going to say this, I think with every statute, every claim, it's just crucial that everything is documented, right? So in order to avoid these Title VII claims or have a strong defense to the Title VII claims, in addition to documenting that everyone's received the policy, everyone's been trained in the policies, you want to document thoroughly your receipt of the allegations or the reports, document your investigation, who you spoke with, keep contemporaneous notes, document everything, right? I think that's maybe your best defense to these types of claims. In addition to documenting again the fact that folks are receiving training and receiving copies of the policy. And as with ADA under Title VII, a prevailing plaintiff may be entitled to recover compensatory damages subject to a cap. In addition to back and front pay, prevailing plaintiff also is entitled to attorney's fees and costs. And I don't have a slide for this, but Title VII works the same way as the ADA with as far as procedural matters, where if someone's going to assert a claim under Title VII, they file a charge with the EEOC. EEOC investigates. They'll probably request information from you. EEOC will make a determination of whether there's some type of cause, or they'll just provide a right to sue letter. If there's cause, that goes to the DOJ. They can continue the investigation. If the claimant receives a right to sue letter, that enables them to hire an attorney, file a pro se action in federal or state court. Okay, so the next statute we're going to talk about is the Age Discrimination and Employment Act, which is called the ADEA. Age, you might have noticed, is not protected under Title VII. A few years after Congress passed Title VII, then they passed the ADA. So it's a separate statute. There are some variations. It protects applicants and employees from discrimination based upon age. It protects individuals 40 years of age or older, which to me seems very young. Now that I'm over 40 years old, I think it's very young. But it prohibits employers from discriminating on the basis of that age in hiring, discharging, compensation, or terms and conditions or privileges of employment, right? So pretty much any kind of employment decision you can make. It applies to private employers with 20 or more employees and to just local governments generally. ADEA claims, they're filed frequently. You don't want to get sued, but I do think that there are some tougher defenses maybe than Title VII or the ADA. It's difficult for plaintiffs to establish these claims. I don't mean to infer at all that you should be more lax with your policies or trying to, prevent these type of claims. But in order to establish a violation of the ADEA, a plaintiff has to either prove through direct evidence that a decision maker, meaning the person who's making the employment decision, made the decision based upon age. And if you read the case law, it requires a smoking gun. So it has to be some age-related comment that is in direct context of the employment decision being made. That happens very rarely. It's very rarely someone says, I'd like to hire you, but I just think, you're too old. Sometimes there are inadvertent comments where when you're talking about retirement, in the context of like making reductions in force, that could be considered direct discrimination, but I think it's much more infrequent. Most of the times, ADEA claimants will try to establish age discrimination through indirect evidence. So in order to do this, it's called the McDonnell-Douglas analysis. An individual has to establish that they belong in a protected age group, which is over 40 years of age, that they suffered an adverse employment action. That could just be any kind of employment decision, right? That they're replaced or treated less favorably than a younger individual. And years ago, it was just if, I think the courts interpreted it as if they were treated differently than someone outside of the protected class, right? Meaning someone younger than 40, but that's not the case. So a plaintiff can establish age discrimination. Let's say if they're 60 and they're replaced with somebody significantly younger, say you're 45, right? You're still within the protected group, but there's a significant difference between the age. So those are pretty easy factors usually to establish. So again, if someone is alleging age discrimination, then the burden's on you, the city, to say, no, we have a legitimate business reason for this decision. And if you're allowed, or if you're able to provide a legitimate business reason, meaning that person had disciplinary issues, performance issues, or you've completely eliminated a position, then the onus goes back to plaintiff to establish pretext. So again, that goes back to the kind of the theme here is documenting everything, right? This pretext analysis and ADA claims can be like a very kind of heavy burden to kind of establish we did not treat younger employees the same. So again, it's really crucial that every department is doing yearly reviews for all employees and documenting any type of performance issues so you can justify why a younger employee might have been treated more favorably than an older employee. And the ADEA does not provide for compensatory damages. It allows a prevailing plaintiff to obtain liquidated damages, which are statutory. Usually that's double of the lost pay. And that statutory liquidated damages are only provided in cases where there are willful violations. But under the ADEA, willful is a very easy threshold for standard to make as a plaintiff. And again, a prevailing plaintiff also is entitled to attorney's fees and costs, which is usually the linchpin and why these cases are settled. So next, we're going to delve into some Tennessee statutory law, the Public Employee Political Freedom Act, called PEPFA. And this is a Tennessee state statute, and it makes it unlawful for a public employer to discipline, threaten to discipline, or otherwise discriminate against an employee because the employee communicated with a public official. So under PEPFA, the employee must have engaged in some type of protected speech, and that's going to be job-related speech that is true, and it's a substantial motivating factor in the decision to terminate the plaintiff. So again, it's that an employee engaged in this protected speech, job-related, true, and that speech was a substantial motivating factor in their termination. And that speech, again, is with a public official. And we're going to talk about the First Amendment at the end. The PEPFA is different than the First Amendment. So in PEPFA, you are acting in the course of your employment when you're conducting this speech. First Amendment, First Amendment, you're speaking as a private citizen. So there's a difference between PEPFA and First Amendment. It'll probably be easier to discuss that when I talk about the First Amendment. In PEPFA, the party is entitled to compensatory damages. And so this statute used to be a much bigger deal, and we would get really nervous when we saw these claims, because in the past, a prevailing plaintiff was entitled to treble damages. And so that was 3 times the compensatory damages in attorney's fees and costs. And I think the Tennessee legislature amended this statute a few years ago. And I think it was after some cities got hit with some pretty substantial jury awards. So this statute has less teeth now. It's a little bit less scary, I guess, than it used to be, but it's still out there. So again, in this statute, there's not a lot of case law on it. And just an example of a case I have right now that's interesting that hasn't been resolved. But it's a small city, and the mayor essentially runs the city, and it's, you know, the HR director, she does everything. So an employee alleges that he complained about the mayor asking him to do something illegal, right? And that she terminated him because of that. The purpose of the statute is more that it's supposed to protect public employees who go around their supervisors and complain about illegal conduct to a public official. But you look at the way these statutes are intended and then how they're used, and sometimes there's a bit of disconnect there. Next statute is the Tennessee Public Participation Act, the TPPA, and this makes it unlawful to terminate employees who refuse to remain silent about illegal activities or participate in illegal activities. So under the TPPA, the plaintiff must establish that his refusal to participate or remain silent about illegal activities was the sole cause of his termination or discipline. So that is kind of a high burden on the plaintiff. They have to show that's the only reason that they were terminated. Under TPPA, the plaintiff must have reported the illegal activities to someone other than the alleged wrongdoer. So that example I just gave, where it's kind of unclear under PEPFA, would not apply here. The plaintiff must have reported it to, doesn't have to necessarily be someone outside of the city, but someone other than the wrongdoer. I have an example right now, and actually a couple of cases where it's former police officers who claim that city councils or BOMAs had a ticket quota, right? And something that was interesting with those cases is at the time the lawsuits were filed, ticket quotas weren't actually illegal. There was no criminal consequences for instituting ticket quotas, but the TPPA says it doesn't actually have to be something illegal, but something that would reasonably be perceived as illegal by the employee, right? So this whistleblower statute does not require that the underlying activity actually be illegal, just that it would be reasonable for the whistleblower to believe that they were reporting illegal activity and that they were fired for that whistleblowing activity. And there are scenarios where the TPPA covers speech not protected by the First Amendment. I'll give you an example. Kristen Brexa and I, from my firm, and I handled a First Amendment case for several years. And It involved a police officer who alleged that he complained to a district attorney about illegal conduct within the police department. And this case actually went up all the way to the US Supreme Court, which they did not review it. They rejected review, but it went through district court, the Sixth Circuit. Both of those courts said that employee's speech was not protected under the First Amendment because this police officer was reporting something in his ordinary scope of his duties, right? Which we'll talk about the First Amendment in a second. In the district court opinion, she said, Judge Trauger said, this speech might not have been protected under the First Amendment, but it would be protected under the TVPA. So that just goes to show a lot of times you'll have these speech cases where you have First Amendment, PEPFA, and TVPA. TVPA and PEPFA can involve, whistleblowing about perceived illegal activity, and that someone's reporting that within the scope of their job. And under the TVPA, the prevailing plaintiff is entitled to compensatory damages that are subject to caps and attorney's fees and costs. I just want to mention briefly a new provision of the TVPA. It really won't apply as much to you all, but the TVPA now includes an anti-slap provision. So basically, if let's say a plaintiff, let's say, files a defamation claim against a defendant. If the defendant in this defamation claim can show that the defamation claim was only filed against them to silence First Amendment speech, then under this anti-slap provision, the prevailing defendant is entitled to attorney's fees and costs, and there's a potential for sanctions. And this issue came up in a recent case where a private citizen sued a city and a city council person for defamation, claimed that the city council person defamed this plaintiff on Facebook, right? They also sued the city. And the city didn't have this defense, but the city council person said, no, you're just trying to, squelch or quash my protected speech on Facebook. And the plaintiff in that case dismissed his claims because he knew he was going to be subject to this attorney fee provision and a potential for additional sanctions. And I've referenced the First Amendment several times. So the majority of my practice is actually more in this First Amendment realm, but we're seeing a lot more First Amendment claims. I think it's a recent trend against cities, but First Amendment protections apply to restrictions by local governments. And you all are familiar with the First Amendment. It protects speech. So this also can apply to the speech of local government employees, right? But no right is absolute, and the US Supreme Court has limited the types of speech by public employees that is protected. So I mentioned previously, just to kind of call back, TVPA and PEPFA. And those claims, those are state statutory claims. A government employee can assert a claim against his or her employer, the city, and say, you fired me because of my speech. Under PEPFA and TVPA, there's a potential that even if that speech was made during the course of their duties, it's part of their job, they might have claims under those state law statutes. Under the First Amendment, however, government employees are not protected when the speech is made as a private citizen. Back up, the threshold question is, so if you have a First Amendment claim, the threshold question is this speech protected? The first inquiry is going to be whether or not it was a matter of public concern. So typically, if it's just an employment issue, right? Let's say someone goes on Facebook and they're complaining because they don't like some new internal policy that does not allow city workers to work remotely. That's not going to be a matter of public concern. Or if it's just a regular run-of-the-mill employment issue and someone, it's usually Facebook, goes on Facebook and complains about it, that's not going to be a matter of public concern. However, if someone goes on a local government city employee goes on Facebook and they're talking about corruption within City Hall, or or a police chief is falsifying evidence, right? That could be a matter of public concern. So once the court determines whether or not the speech itself is a matter of public concern, the next inquiry will be whether or not the person was speaking as a private citizen. The inquiry is whether or not the speech was part of the employee's ordinarily due. If it's a speech that was part of the employee's ordinary duties, the speech is not protected. So again, the example I gave previously, if it's a police officer who complains to a DA, which is a case that we have, if that police officer, it's within the ordinary scope of their duties to discuss how a criminal action is being investigated that was referred to the DA's office, that's going to be part of their ordinary duties. Or if an employee is making some kind of like complaint about some kind of like internal function, let's say an accountant is complaining to a supervisor about the way or the methodology that the books are being done, that's within the ordinary scope of their duties, and that speech is probably not going to be protected. Even if an individual is speaking as a private citizen on a matter of public concern, the court still might not deem that speech to be protected. So the court does this kind of balance of the interest in communicating the speech and the interest of the employer. And it's kind of hard to give an example, but in some contexts where there have been public grievances made about like the internal operations of a police department that disrupt morale or somehow affect the operations of the police department, can't be about corruption. Sometimes it'll be in the interest of the government that type of speech outweighs the interest in the individual communicating the speech. Sorry, I'll give you a better example. This comes up in the context sometimes of people making discriminatory or inappropriate speech on social media. So for example, there have been cases around the country where police officers have used derogatory comments that say in the George Floyd situation. The courts might say that's, he was speaking in his private capacity as a citizen, it's a matter of public concerns, police violence. But if the speech was so inflammatory that it caused such disruption in the community, caused disruption in the police department's operations, while that individual speech might be protected if they weren't a government employee, the court might do this balancing test and decide that the interest in communicating the speech is outweighed by the interest of the employer in terminating that employee. It's a very complicated area of the law. It's hard to discuss in this short amount of time. So if anybody has any questions about that, let me know. And quickly, I want to address due process and property interests. Another very common claim we have with former government employees are due process claims. So under the Fourth Amendment of the US Constitution, public employees may have a property interest in their continued employment with a local government. And it basically means that if there is a property interest, and if someone has a property interest in their job, their continued employment, that they are entitled to have the right to due process hearings prior to termination or other types of discipline. In Tennessee, state law determines whether or not there's a property interest in someone's employment. As I'm sure you all know, Tennessee is an at-will state. So it's important to check your city charter, employment policies and manuals, and employment applications to make sure there's no language that would even give kind of an inference that someone has a right to a hearing prior to termination or prior to an adverse employment decision. Some cities want their employees to have a property interest and have the right to hearings, and that's great if you do. But an example, we have a city recently who provides a property interest to some employees, but does not provide like due process rights to probationary employees, right? So that language needs to be very specific in your employment policies and in every document that the city has, charter, employment applications. If you are providing some folks with the right to hearings, due process hearings, prior to or following termination, make sure that it's explicit in whatever policies that you have. And that seemed like it went very quick. Oh, one more slide, sorry. Another issue that's come up recently is training city officials. So there is no Tennessee requirement that city officials, meaning elected officials, have to obtain training. But sometimes, members of city council, member of BOMA, sometimes their actions can expose the city to liability, or sometimes like their communications are subject to discovery or to public records requests. So last thing I wanted to encourage is, even though training, we talked about training for department heads, employees on policies, even though it's not required for city officials, I strongly encourage city officials, or for you all to encourage city officials to attend voluntary MTAS training. And again, this comes up in a lot of ways, but what we've seen most frequently is once cities are in litigation, issues will come up about city officials using their personal devices to communicate city business or their personal emails. So just that city officials be aware of how their actions might impact litigation. Right, so does anybody have any questions?
We don't have anything in the chat box currently, but if anybody would like to add any questions to the chat box, we have time to take questions. While you're thinking of all those good questions, I will let you know that our 2022 Risk and Insurance Symposium is scheduled for August 24th through 26th. Registration is now open on our website. That's www.pepartnersplural.org, where you can give me a call if you have any questions, but there is information on our website for that currently. Not seeing any questions. Casey, we really appreciate your time today on such a timely topic and such an important topic for our members. We definitely had great interest in the webinar today, and we appreciate you taking time out of your busy schedule to help us with this. Any final thoughts?
No, my pleasure. And if anybody has any questions, I know we covered it. This was intended to be an overview. So if anybody has any questions, again, Casey Crane, Fair and Bates, you can look me up and feel free to call me or email me. I'm happy to chat.
Perfect. We had a comment. Someone just said good information and thank you.
Oh, good. Thank you so much.
We appreciate everyone today. Again, everyone who has participated today will be receiving a link to the video when it is ready. And we appreciate each of you spending your afternoon with us. Have a great day.